afternoon, and welcome to Thompson Hine's Investment Management Coffee Chat webinar series. My name is Andy Dvala, and I'm a partner in the firm's investment management practice group. Thank you for joining us for today's session, part of our ongoing coffee chat series designed to provide concise, practical discussions on timely topics impacting the financial services industry. Today's program is titled A Practical Roadmap to Starting an RIA. Launching an investment advisory firm requires more than a strong business concept. It also involves thoughtful planning around entity structure, registration, and ongoing compliance obligation. During today's session, we will discuss key considerations such as selecting the appropriate business structure, determining fee arrangements, and navigating state versus federal registration requirements, among other practical issues. I'm pleased to introduce my colleague, Sahar Hamidat, counsel in Thompson Hine's investment management practice based in our Los Angeles office. Sahar brings valuable perspective to this topic, including insights from her prior in-house roles. Before we begin, I also want to mention that we'll be hosting an RIA merger conference in our Los Angeles office on April 29th. The event will take place in person with a virtual option available for those who are not located in the LA area. Please feel free to reach out if you like additional information. During today's program, we encourage you to participate by submitting questions through the chat box at any time. We will address as many as possible during the session and follow up afterwards on any we are unable to cover. You should also see links on your console screen to register for upcoming coffee chat sessions, and we encourage you to explore those as well. Finally, please note that this discussion is intended for the general information of individuals and organizations on matters of current interest. It is not intended as legal advice, and participants should not act on the information presented without seeking professional counsel. With that, let's go ahead and get started. So, Sahar, from your experience advising clients on launching their own RIAs, what are some of the common challenges that you've seen that they've faced during the formation process, and what steps can they take early on in the process to avoid those pitfalls?
Well, first of all, thanks, Andy, and thanks for the introduction. I thought that the best way to start here would probably first be to define what is the Investment Advisors Act and the requirements for a registered investment advisor under the regulatory body that governs RIAs, registered investment advisors, which is the Investment Advisors Act of 1940. That being said, investment advisor defined under the Act is basically any entity/person that advises or engages in the business of advising others when it comes to the value of their securities or what assets they should invest in or selling securities. So basically providing any sort of advice regarding securities and doing so as a business and for compensation. So just to be clear, 3 essential requirements bring a certain entity into the umbrella of being regulated on the Investment Advisory Act. So that is, again, 1, providing advice about securities, 2, doing so as a business, and 3, receiving compensation for the advice. So once a firm determines that, they have to register with the SEC as an investment advisor, which they pretty much have to if they meet those 3 requirements, unless they fall under a certain exemption, which we can talk about later, and also about whether or not they meet a certain threshold. It's at that point that they need to, either counsel or a consultant to discuss whether they fall under the exemptions and whether they have to register. That being said, registering is a very complicated process, and it's ongoingly complicated. So in terms of what are the most common challenges and pitfalls that we see when registering for an investment advisor is, some few basic things. One is just even understanding the time and complexity involved. Many clients that we have initially assume that they can do this on their own and quickly realize that this is a lot more complicated than they initially thought. The second is to realize that, they need to have a realistic compliance budget when it comes to setting up and forming a registered investment advisor and for potential ongoing advice regarding compliance, especially if they don't have someone or a robust compliance department in-house. The other thing to think about are the business structure and the implications that go along with that. Now, in particular, I'm talking about entity formation. So should the RIA be an LLC or should it be a corporation? Those are the more common ones that we see. And there's different implications for both. And so just understanding what is the best structure for a RIA, newly formed RIA. And one of the other couple pitfalls I see that are pretty common is that, having the client or having the RIA understand the timeline realistically. I think that a lot of clients think that forming an RIA and getting it through regulatory approval is pretty quick, which it can be or cannot be depending on the complexity and the examiner that you are assigned. So just having a realistic timeline, I think, is very important. And just being very aware of the different complexities that can come down the pipeline later in time with ensuring that the RIA is formed initially well and that everything's thought through prior to just hitting the button on the SEC registration.
That's correct. And I think it's important, I think Sahar brings up a very good point about entity formation and thinking about that. Generally speaking, our corporate partners here at Thompson Hine, obviously you can use different entity types. They generally suggest using an LLC that's taxed as a partnership. They believe that this gives the most flexibility in terms of different classes of equity in the entity, allocation of profits. It makes it easier to acquire potentially other IRAs or sell your own business if that's potentially something that's a goal down the line. Also, when forming the entity, making sure that all equity issuances, any restrictions, covenants, anything of those types of natures and rights are all well documented. Because if you are looking to either sell or acquire another business, and you have a partner that may have certain rights, and that's not well documented, obviously that can make an acquisition or disposition more complicated. And then we also suggest having a holding company above the RIA, where the RIA would be a wholly owned subsidiary of the holding company. That just makes it cleaner, have all the IRA operating activities at the subsidiary RIA level. And that also allows flexibility in the future should different types of business, non-IRA businesses, but related businesses such as maybe insurance or broker-dealer, forming another subsidiary under that holding company. That structure gives you that flexibility as well. So important to get that right and well documented at the outset of starting your RIA. With that as background, maybe we could, talk a little bit about, the registration process, Sahar, and kind of what some of the options are there. Obviously, probably the first kind of issue that people would look at is state versus federal registration. So can you talk a little bit about those issues and what potential advisors should be thinking about there?
Yes, absolutely. So I would say the next step is once, a client for an RIA determines that, yes, I want to go ahead and register. What does that mean exactly? And what are the different options? So to be able to federally register, you need to hit $100 million AUM meaning assets under management. So once an RIA hits, or gets close to hitting $100 million of assets that they're managing, it's at that threshold point that they should register federally. Now, prior to that, up to 100 million assets, they need to register with the states. They, meaning the RIA, needs to register with the states in place of where they're doing business, essentially. And many times it's more than just one state, it's multiple states. So it can get tricky, especially when you are under the $100 million threshold, because then you have to make sure that you are complying with any of the states where you're doing business and their individual regulations, which are different state per state. So that is one thing that I think is a very common pitfall, where we see RIAs trying to, for only registering in a state where they believe that they need to, where they do business, but may have clients in other states. And so it's very important that once you do determine where one of your clients is doing business and is having you invest their money, that you do so you do check the state requirements. Now, and each state is different. So every state has its own regulations. Once you do hit the $100 million threshold and you have to register federally, it makes things a little bit easier, because then you just have to indicate on your Form ADV, which is the actual document that you use to file, register the investment advisor, which different states you do notice filing for. And so that's just a checkbox situation. And then the states reach out and you can just comply with the regulations once you go through the states, what you need from that, what they need from you, how much money annually you have to pay to be registered in that state, etc.
Yeah, and I think Zahar brings up a good point. It really can be very state specific. So, what you may need with one state regulator, you may not need in another. So it's important to determine what those requirements are. You may have to provide financial statements to one regulator. You may have to get a compliance manual, proof of insurance. It's really a potential myriad of potential documents that you need to provide to the state regulators. So being aware of where your clients are and the thresholds associated with complying with each state is really important. I also do want to mention that if your intention as an advisor, or that if you are going to be advising any type of registered fund product, so that could be a mutual fund, an exchange traded fund or ETF, an interval fund, closed-end fund, any product that is registered under the Investment Company Act of 1940, you are required to register federally. So even if you do not meet the AUM threshold of 100 million, as Zahar noted earlier. So that's important to think about, if that's the type of products you will be providing investment advice to. There's also kind of different potential registration exemptions. One of the ones that I'll just mention here is the private fund exemption. If you are exclusively advising private funds under $150 million in assets, there's kind of like registration light, if you will, for that group. So it's really, when you're going through this process, thinking about the types of investment products you want to offer, who your client base is going to be, and then doing the research to see what makes sense for you and where to register.
Yeah, absolutely. I mean, I find that it can become very complicated very quickly. And, like I mentioned, there's the $100 million threshold, but then there's also exemptions, Andy, like you mentioned, where you have to register even though you have less than $100 million assets under management. So really understanding those nuances and how, for example, you mentioned private fund exemption. How is a private fund defined under the Advisors Act, which is very different than what, you and I just, so not doing this on a daily basis. No. So
A lot of the terminology is not typical terminology. And so just for example, a big pitfall I see often is that when folks are trying to register their investment advisor and they're trying to figure out their AUM, regulatory AUM is what the ADV requires, which is very different than the just general definition of AUM. And so those small nuances that are not known or obvious, I should say, those can cause a lot of problems down the road where it just delays everything, or, the regulators come in and ask a lot more questions, or you don't want to do anything that even causes a potential deficiency. So just small things to take, careful thought.
And I think this is a good point, and I think you'll see us reemphasize this through the rest of this presentation, but, really partnering with either, a firm like Thompson Hine that is involved with this. They're also very well experienced compliance consultants that can help on the registration process. So it is very difficult to navigate alone. So bringing in, counsel or a compliance consultant to assist you with this process to make sure that you set your business up right on all facets, I think is, important and something that we'll continue to discuss throughout this process. Getting back to sorry, go ahead. Sorry.
I was just going to interrupt for a minute and say, not only is it with respect to setting up the business, setting up the RIA, but I also think that given the Advisors Act has continuing obligations, whether they're quarterly or semi-annually or annually, it's important that, the firm stays on top of it. And a lot of times that's something also that needs to be considered and outsourced if there's not enough robust in-house counsel to work on those matters. So yes, also during the formation, but also continuously, because not only do the rules and regulations constantly change, but also there's a lot of continuous compliance work in maintaining a registered investment advisor.
Certainly, agreed. With respect to registration, obviously there's Form ADV, which you'll need to complete whether you're doing state or federal registration. Sorry, maybe could you talk a little bit about the different parts of the ADV and some of the issues and pitfalls that are common when a new advisor is completing those documents?
Yeah, absolutely. So the ADV, the document, again, the official document that's used to file in order to register for an investment advisor, is a 3-part document that is filed with the SEC through the RIA system. And so that is just, basic ADV filing. There is, again, like I said, 3 parts. There's part 1, part 2A, and 2B. And there's also a shorter form, which is called the CRS filing. And it's really important that firms understand all of those different parts and what they're used for from the get-go. They are public filings and available to the public. And for that reason, a lot of potential clients and advisors use them when making a decision, as a reference base when making a decision of hiring a RIA. So just as an overall structure, the ADV covers pretty much everything and anything having to do with the advisor. The first part of the ADV is a little bit simpler to review, given that it's broken down into parts with it's less paragraph. There's less paragraphs and more just broken down parts where someone can quickly look up the regulatory AUM, how many employees, where the history of the firm, the types of assets that they review or that they manage, and any other sort of quick facts. So most people will go to the Form ADV Part 1 for those type of answers. Now, the Part 2 in general tends to be more detailed, more paragraph long answers
every conflict of interest that's, an issue at hand, just anything that that FINRA and the SEC deems is important for full transparent disclosure. So that's a much longer document, long paragraph forms. However, has every detail that any investor would want to or need to know. And those two parts, the A and B, just basically divide up the firm's information and then the background of the employees or advisors of the firm and their bios and their backgrounds. So that's pretty detailed in all aspects. So that's that. I don't know if Andy, you want to talk about some conflicts of interest issues that do come up that are required to be disclosed in the ADV.
Sure. That'll be in the part 2. Conflicts of interest. Obviously, all the sections of the part 2 are and the ADV as a whole are important. I think one of the common pitfalls I see is the conflicts of interest. So if you as an RIA have any, say, affiliated arrangement with another RIA, a solicitor, any type of relationship whereby, you may be put in a situation where your client's interests, which you should be placing first and foremost as a fiduciary to those clients, and then other relationships where maybe you're getting a referral fee or some other type of arrangement which benefits you as an advisor. And certain of those arrangements are certainly permissible. However, you just want to make aware, your clients aware and the public aware of any relationships that would create a conflict of interest for you. And I think this is a section where it's almost impossible to over disclose. So even if it's the optics of a potential conflict of interest, I would very much emphasize and push for disclosure of that. There's no downside to including that types of information about those arrangements. So I think it's really important so that in the instance that where a client comes back and questions why you did something as an advisor and as their fiduciary, and they find out that there was a certain relationship that you benefit from as a result of managing their account. There certainly have been actions taken by the SEC as well as clients privately regarding those issues. Another item I wanted to note that Sahara raised was the kind of difference between regulatory assets under management and regular AUM. So there's very much a strict definition of what constitutes regulatory AUM under Form ADV. So, please be careful when considering what your regulatory AUM is. And then once you have established that, one of the things that I've seen in the past where advisors have tripped up is using a different number in their marketing. So there's a disconnect between their marketing and ADV and how they compute those numbers. And also for, some of us are aware of, sometimes an advisor may provide, say, like a model portfolio, but doesn't actually manage the underlying account. Sometimes people refer to that as assets under advisement, which is not a regulatory or legal term. And those types of assets, more likely than not, are going to not qualify towards your regulatory AUM. So you don't want to have them counted towards that amount, either for the $100 million threshold or in any event, because the SEC has taken actions in instances where those assets have been reported as a firm's regulatory AUM. And, essentially the SEC believes that the advisor was looking to inflate their overall assets, to look stronger to the public. So just, again, consult with your counsel or compliance consultant, again, when going through this process and thinking about those issues. Maybe kind of transferring from, a little bit from, registration. So we have the Form ADV, which we file on the at the outset of registration, and then you also have to update that annually. A lot of people are in the ADV update season right now, as they're due by the end of this month. So you have to do an annual update, and there's also you may have to do intra-year updates depending on certain developments or other things that happen at your firm. So again, just look at the instructions, work with your professionals to determine if you have to amend anything during the year. But otherwise, you do have to update your ADV at least annually. Maybe transitioning. Sorry, go ahead, Tom.
Oh, sorry, Andy. Do you think we should talk a little bit about the CRS filing? I don't know if I.
Yeah, sure.
Discuss.
Yeah, if you want to take a couple minutes to discuss that, that'd be great.
So the CRS filing is the fourth filing that we had mentioned, which is basically a shorter form file document for potential investors, and that has to be given to those investors upon contact and discussion about the advisory business. So it's a lot of the same information, just cut down and easily handle, something you can hand to a potential investor when they're considering engaging. Yeah. I think there's anything more that we need to, I think that's pretty.
Yeah, I think we could move to kind of, compliance infrastructure, and, Sahar kind of laid out at the beginning, thinking about having, what devoting enough resources in budget to having an appropriate compliance infrastructure. So, how should a new RIA approach kind of setting up a compliance framework, policies and procedures, and think about that process?
Yes, absolutely. Having been in-house as a chief compliance officer for many years, this can be very, very daunting task. So first off, it's mandated that every RIA has a robust compliance program. And I can tell you that from my experience, that is the lowest hanging fruit for examiners. So it's the easiest thing for an FCC examiner coming in to examine, just a surprise audit visit to examine a registered investment advisor to see that that's the first place they'll go, is the compliance manual. Have all of the required elements, and also are they being followed? And they will ask for documentation to ensure that every regulatory mandate, again, whether it's monthly, quarterly, annually, are being followed. So documentation is key when it comes to that. And why do I say it's complicated, robust, it can be daunting? Is because the compliance manual consists of policies and procedures that must be followed and are required, and also the code of ethics for the registered investment advisor. And those two, everything within them has to be followed to a T and documented. And if not, it's an easy place, like I said, for examiners to nail, I should say, registered investment advisors. So going to what is actually required to be adopted and implemented when it comes to the Advisors Act requirement of having a compliance manual. And what the Advisors Act says is that that every advisor has to have a written policy and procedure reasonably designed to prevent violations of the Advisors Act. So pretty broad, but yet very important that they follow. They have those written policies and procedures and then also follow them to a T. The reason this can be difficult is because, the regulation does say, quote unquote, reasonably designed. And I think the reason for that is they want to ensure that there was thought put into the policies and procedures that were created, and that the policies and procedures really are tailored to the firm's type of business. So policies and procedures for, say, a mutual fund versus private funds would be very different, and the required mandates would be different. Some policies and procedures would require tight rules and regarding trading and insider trading policies to prevent insider trading, and whereas others types of companies or for registered investment advisors don't necessarily have anything to do with
trading on a daily basis, and so they will have a different type of policy and procedure that the firm would have to follow. So I think that it's just really important that a lot of time and professional thinking is considered when sitting down to decide policies and procedures. It's not, I've seen some consultant shops where they'll have just a standard package that they templated policies, and then they just get, change the names and change a few items. But in reality, there's no real generic policy and procedure. They have to really be thought through and tailored to the TECA's RIA. Some of the things I've seen is that, in particular with smaller firms, maybe even individual owner firms, investment advisors, they can't afford, to necessarily hire a law firm, a big law firm, but what they do is hire consultants that can help them get going and set up the RIA. But then it's very important that they can, take it on their own afterwards, but that they follow all of the rules and regulations and ensure that they're up to date, because these regulations are changing on a annual basis in different ways. So just really staying on top of the changes as well is very important. And also, as the firm grows, it's important that, you keep in mind that there has to be an increase in the budget for compliance. And I think a lot of times that's forgotten. Being in-house for so many years, I realized that, nobody likes compliance in terms of the advisors, because it's a cost center, not a part of the business that brings in money. So we're not always loved by the folks that work at registered investment advisors. However, they're crucial. Compliance folks are crucial because they do keep everything running smoothly and, prevent the firm from being shut down or being fined. So that being said, it's important to keep in mind that as the firm grows, that the budget expands accordingly.
Yeah, and I think it's important to, what Zahar noted, that, obviously we're mindful of resources potentially and budget constraints for newer advisors as they, bring their firm into being and are setting up a compliance program. Like she said, you don't want the off-the-shelf kind of compliance manual that a consultant may give you. It has to be tailored to your business. So if your compliance manual is very generic and you do certain lines of business, say it's like, private funds or mutual funds or separately managed accounts, the details of those policies have to be crafted in line with those products so that the SEC will believe that your compliance policies and procedures are reasonably designed to not violate the federal securities laws. I think it's important, again, to find the right compliance consultant. And obviously there's compliance consultants that will act as like an outsourced CCO. Every advisory firm needs to name a chief compliance officer. So certainly there are services out there that will act in that capacity. Sometimes it's that function is maintained internally. Maybe an advisor has the resources to have a dedicated chief compliance officer with the appropriate background and experience and resources. And so that function can be wholly taken care of within the advisor itself. And sometimes there's something in between where maybe one of the principals at the firm is wearing a couple different hats, one of those being CCO. And I think that's where it's important, to find and maintain a good relationship either with a law firm or a compliance consultant, whatever works for the advisor, so that, the CCO in-house who's doing other things besides compliance can keep up to speed with everything that's going on in the industry, because there is obviously just on a daily basis potentially certain testing, reporting, other items to address continually. But then as Zahar noted, I mean, this is obviously the regulatory framework in which advisors operate in is continually evolving and changing. And so in one of the priorities, the SEC noted in their examination priorities for this year was, how advisors were complying with new regulations. And so if your compliance manual doesn't reflect the effect of new or revised regulations on your policies and procedures and how they affect your business, then obviously they're going to find that your compliance manual is not reasonably designed. So just finding the right framework that works for you, that is dynamic, either by internal resources that can stay on top of this, or working with a good outside professional to make sure that the advisor is keeping up to speed with all the changes, and as well as the daily and regular reporting requirements of an investment advisor. I think it's just really, really important to get right and have that framework in place, because at some point, every investment advisor is going to be examined by the SEC. One of the first things they're going to ask you and their information requests when they come in is your compliance policies and procedures for the examination period. So obviously you want to have a good story to tell when the SEC does come and ask you for those documents. So getting it right from the outside and making sure it's working on an ongoing basis is important. If you didn't have anything else on that, Sahar, maybe we could pivot to maybe some of the new developments in the industry.
Yeah, no. And the one thing I also wanted to mention was part of all of these different rules and regulations is also the oversight over IARs, which are the actual investment advisors, the folks that are registered as advisors and that work with a registered investment advisor. So they have their own set of rules and regulations, and the firm and the compliance department of the firm is responsible for ensuring that they're meeting all of their requirements as well, whether that's state or whether that's licensing requirements. So I think that kind of falls under the same bucket, but I did want to point that out.
Sure. No, good point. So why don't we think a little bit about, okay, now you have all this in place, you're, looking to grow your advisory business, market your advisory business. The SEC's new marketing rule significantly changed the landscape for investment advisor advertising. Can you maybe talk about some of the do's and don'ts an RIA should keep in mind as they're trying to, now that they're operational, build their brand, client base, and thinking about, the use of testimonials, endorsements, social media, those types of things?
Yeah, I think that's great. So, I think the next step, the next big step I would say is the firm obviously wants to market, their advisory business, and what are they allowed to do and not allowed to do, and the rules and regulations involved with, marketing and advertising. And I guess the first, complication, or I shouldn't say complication, but, a lot of times what happens is these programs are started by individuals or just one or two individuals, and they have to have a compliance officer. So the founder and the compliance officer will be the same person, which causes conflicts of interest that have to be well thought out of, and a supervisory framework that has to be drafted and created to ensure that there are conflicts of interest that are, not fair when it comes to the investors, the clients of the advisory. Again, this is a very complicated and a very common challenge that we see with small to mid-size regulatory firms. And so I would say the first thing is that it's really important to build out a procedural safeguards to ensure that the supervisory function exists, even if there isn't a supervisor. So how do you do that when, you're just starting out, the firm is just starting out, their budget is very low? This usually involves with just documenting and reviewing processes. Like everything that an advisor does needs to be documented, and all of the different considerations that were taking place into a decision that a investment advisor moves forward with all of the pros and the cons. Everything should be considered and, again, documented. Something that's very, very important. I will say over and over again, because the SEC does come in and does ask for documentation as to why certain decisions were made. And so, again, I think that's really important. I think another thing that's important is like regular self-assessments. So it's like internal audits. For example, when I was compliance officer at a smaller firm, what we would do is create our own ad hoc compliance audits and a write-up summary, again, documentation that we did it and what the results were. And there's many different areas that can be audited, and, whether that's the fees or whether that's, auditing the way certain investment decisions were made, and, aligning that, ensuring that aligns with the policies and procedures of the firm, and that there were no, and that everything was done fairly. Again, I think that's a really good way to show the SEC when they do come in that, look, we are trying to be a very compliant organization, and this is what we do, and here are the documentations for it. So I think that's really important. If you are a solo advisory firm, the other recommendation I would have is to create checklists. There's a lot of requirements, and they're continuous, and those requirements can be hard to remember if you don't have some sort of oversight by a third party. So checklists, compliance checklists are the best thing. Maybe when you first form the advisor, to ask the attorneys helping you form the RIA that you would like some sort of ongoing checklist to pinning dates to ensure that you don't miss any major compliance deadlines. So that's something I think that is also important. A lot of smaller firms will also create advisory boards or use third-party service providers to just do a second or third layer of checks. So even though you're doing it internally, maybe every other year it's worth getting an outside third party, whether it's a lawyer or a compliance consultant, to do their own auditing. And these mock audits are very common amongst smaller firms. Some do them on an annual basis, and those that are really small will do them every other year. But I think that way you can show the results to an examiner when they do come knocking on your door, and also show that you've implemented any issues that they found during the mock audit. So I think that goes a long way with examiners.
Yep. And like I said before, every investment advisor is going to be examined at some point. And we'll tell you, the SEC is going to find something, especially if you're, it's your first exam. And hopefully, even if you've done all the things that we talked about today, chances are you're going to receive some findings. Hopefully it's something as, hey, can you amend this policy to better discuss this, or, keep better records around this type of activity, stuff like that, that's easily addressed. And then, what's important though is whatever those findings are, that you address those findings. Because where the SEC does get upset is if in the next examination, if you haven't addressed those initial findings from your first examination, they'll consider that to be recidivist, and will potentially come down hard on you, either through some type of fine or referral to enforcement, other type of action that you certainly don't want to spend your time or money on. So be aware that you will be examined at some point. Again, like we said, work with your professionals during that examination process, and whatever findings they do have, address in a meaningful way. And, hopefully, the SEC will be satisfied with that, and your next examination will go more smoothly. One of the items I was going to talk about on the marketing front is a lot of, potentially new advisors. Maybe they manage their own account in a certain way, or, and they say, hey, this is the same strategy. I ran my own personal account. This is kind of either the hypothetical or back tested or whatever performance that I put together. Just be very, very careful when using that. It depends on the audience and the disclosures and whether you can even use that. So anything that has to do with performance, please consult your professionals before doing that. And also, to Sahar's point, like anything, you must, maintain books and records to substantiate on your performance. So even once you start actually managing client money and you're putting together performance for those accounts, to create, maybe a composite of all the accounts that you manage in the same strategy, please maintain the appropriate records to substantiate any of those types of performance numbers that you're going to use in marketing. Just because when FINRA or the SEC comes in and asks you, where does this come from and where did that come, that number, how'd you arrive at that number? You want to be able to show where it came from.
I just had a point there that, Andy, I don't know if this is from your experience as well, but marketing is really the lowest hanging fruit for the SEC. And so they really scrutinize marketing. And, if you're a firm that does do a lot of marketing, I highly, highly recommend having either someone always review the marketing that's going out of the firm, especially if it's continuous and changes versus templated marketing. And even templates that are created, I think it's very important to first get a sign off and have a outside third party consultant or attorney review them, because again, it is the lowest hanging fruit. The marketing rules are also always changing. So recently there's been a lot of modernization to the marketing rules, which is great. But with that modernization comes, really detailed disclosures that are required. And it's not, yes, we all know, marketing shouldn't include any material, non-public information or should, misrepresent with numbers in any way, but you can easily think you're doing the right thing. And in fact, it's a huge violation with the SEC. So again, it's really important. I highly suggest before going down the marketing route to ensure that somebody, either a consultant or some professional compliance consultant, or attorney reviews your marketing, because again, and I would do that continuously, either if it's templated thereafter, then maybe on a semi-annual basis, because again, the marketing rules are always changing. So I think that's really important.
And obviously social media has played a big part of marketing. So, what you may be posting for the firm on LinkedIn, other social media sites, that can constitute marketing. So think about the process for reviewing that. Obviously, there's sometimes a tension between the marketing, sales, and the compliance requirements.
There's always,
marketing and sales might want to react quickly to some type of, either issuer specific event or macro event and put out something to show that, hey, our firm is on top of this. And, we want to be put that out as quickly as possible. But being mindful of the framework, that's the hardest one over, to make sure that it's being reviewed properly before it gets, posted out there. Because again, the SEC is aware of your social media sites, and will review that as part of your examination. So just,
we're employing social media sites. So that's also really important to consider. So if one of your employees puts out, a tweet about how great one of the funds is doing, and there's no sort of disclosures that are required around it, that could be a big problem for the firm as a whole.
Yeah.
So you have to have very tight and robust policies around social media as well.
Yeah. I think we could probably talk about social media and marketing for another half an hour. So maybe we'll just leave it as that, as another potential pitfall to kind of think about. And, from there, and the other thing I would mention is, and this has been from my in-house experience, and maybe Sarah's seen it too, I've always been presented with, hey, well, this other firm does this, and this is what they're putting in their marketing. And, that's not a basis for saying it necessarily complies. So, your legal and compliance function has to worry about what you're putting out there. So, just be mindful of that. That's other people, what they may be putting out there may not comply, and that should not be a basis for your non-compliance. So maybe we'll talk a little bit, as we're talking about growing the firm, Sahar, maybe you could talk a little bit, some RIAs depend or not rely on third-party referral or solicitor agreements to generate new clients. Can you talk a little bit about those and what advisors should be thinking about?
So talking about, I guess maybe we could talk about the service providers. Is that what you're referring to, the service providers?
Yeah, well, we could talk about that, or because kind of like the solicitor agreements, things that, if someone, if you're going to someone that generate business, just making sure that's, that agreement is documented properly.
So first off, if, somebody is referring business to your investment advisor, everything has to be disclosed. So the client, meaning the investor, needs to know that a certain referral came from some promoter of some sort. And so that the client is aware of all of the different parties and the involvement between all of them. So, they need to know the referral arrangement, how much the client should know the referral arrangement between the two parties. And they should also know what it entails, what the referral entails, and how the referring person or entity is being compensated for the referral. So a lot of disclosure is required there. A lot of transparency is very important. That's one when I think that is a important issue when it comes to referrals. And the other thing I would bring up is that, due diligence before engaging any promoters is critical. And there has to be a policy in place that, works for your type of firm for ensuring that all of the promoters' relationship and arrangement with the firm is, very well documented and continuously documented. And there has to be a very robust process for monitoring these activities. So, again, it's another hot topic. It's another place that, firms get in trouble quickly because there has to be really robust policies that have to be followed and then documented, again, for anybody who comes in after the fact or regulator and questions the referral agreement and arrangement. And these referral arrangements are also with respect to service providers, including like the accountants, other attorneys, or other professionals that can be valuable to, the growth of a law firm. So, of a registered advisor firm.
Yep. Great. Thank you. Maybe kind of thinking a little bit more holistically, obviously the investment advisors kind of in managing a client assets, whether that's a separately managed account, private fund, registered fund, wherever the case may be, is kind of part of a broader ecosystem. Can you maybe talk about some of the other service providers that an advisor is going to have to engage with, and kind of that oversight and due diligence process when looking at those providers and how they work with the advisor in servicing a client account?
Absolutely. So, just starting with some of the basic service providers that all RIAs need to engage. Obviously one is the custodian. So they have to select a custodian, and it's crucial that they should be not only doing their due diligence initially when considering which custodian to use, all of their diligence in picking the custodian should also be documented. And that diligence, regarding that service provider should definitely be considered annually. So every year, it's really important that the executive folks sit down, look at every single service provider, the custodian, the broker, the, transfer agent, whoever it may be, and discuss and look at others to compare other service providers in the industry that they can compare the fees, their diligence, the reputation. So the SEC will ask, show us your diligence when you first hired on a provider, and show us continued diligence review of these service providers, on a annual basis or semi-annual basis, but minimally annual, and show us that you actually went out to the market and looked at other service providers and still came back with the conclusion that the service provider you have is the best for your firm, and for that reason you're keeping such service provider. That also includes requesting updated information from your service provider. And so, you always need to keep and document all of the fresh new documents that a service provider will provide, any updated documents, SOX reviews, and then show how you guys came up to the decision of keeping the same service provider if you do. So I think that's really important, and a robust policy around the diligence of third-party service providers is highly scrutinized.
Yeah. And I think this would be, an area, not necessarily where it'd be just focused on this, but annually your CCO is going to have to do what's known as the 20467 report, and that's basically an annual risk, compliance risk assessment. And that often covers key service providers. So it's a lot of the things and documenting that annually, that report, but that report's going to be based on an ongoing annual oversight of these service providers. So the things that Sahar just talked about, the initial due diligence, selection process, but then, what ongoing due diligence? Are you going on site to see what's going on with that service provider? Are you meeting with them? Are you getting, the SOC 1 or whatever, reports about their internal controls, policies and procedures, their cyber practices, all of those things, and then documenting that as a basis for your 20467 report, so that can back it up in evidence that you are, you do indeed have a robust compliance program that oversees these key service providers, that are part of you serving your client account. So, I think we just have a couple more minutes. So, Sahar, maybe to close a little bit, based on everything you've seen advising your RIAs, what are a few of the single most important things that you would, point out to individuals who are looking to, maybe consider this and take the first steps to starting a registered investment advisor?
Yeah, so I think now more than ever, it's crucial to hire a consultant or an attorney to help with setting up the investment advisor, doing training for the employees or any others that are working with the advisor, because the rules are just getting more and more complicated. And now that with social media, and now even more so with AI coming into the fold, there's just so many things that a advisory firm has to be aware of, it has to be on top of. And for that reason, having, a compliance officer who is just a compliance officer, not wearing different hats, I think is, crucial. And I think if you're in the beginning stages, having an attorney that can help you sort of keep things and lightly touch the regulatory advisory items on a quarterly basis is a good idea, because as a small firm, it'll be very difficult to do single-handedly. And again, I think there's so many different areas that firms have to be aware of. And then there's a lot of policies in the making right now with the ever-changing landscape. Again, with social media and AI and everything that's happening. You don't want the SEC to come in and ding you and fine you. So again, just, being able to set up policies and procedures, knowing which policies and procedures have to be set up, which ones should be set up based on your type of business, so the tailored to your business, and then also ensuring that there's ongoing monitoring of those policies and procedures. Another portion we don't talk much about is the code of ethics. And the code of ethics, I think, is a really important part of the overall compliance firm, and ensuring that all of your code of ethics, which includes all of your employees and access persons, so people who have access to the advisor, are doing their diligence in filling out all the information they need to and completing everything that they need to, because again, the advisory firm is responsible. So a lot to do, a lot to think about. And I think my biggest advice would be, if you don't have a background in this, reach out to someone who does to help navigate.
Great. Thank you. Well, that concludes today's coffee chat session. On behalf of Thompson Hine, thank you for joining us. We hope you found the discussion informative and you continue to join us for future sessions in this series. Please keep an eye on your inbox for invitations to upcoming programs. Our next coffee chat will take place on March 31st, where we'll discuss how to launch a broker-dealer. If you have any follow-up questions or would like additional information about today's topic, please feel free to reach out to us directly. Thank you again for attending. Enjoy the rest of your day.
Thank you.